Good afternoon, everybody. Welcome to our fifth episode in the Financial Poise series, Life Sciences and the Law. This episode is going to focus on intellectual property in the life sciences industry. What it is, why it's important, how do you protect it, what current trends do you need to be aware of, and we're going to even touch on AI. IP in life sciences is utterly fascinating. A really valuable, lucrative company can be built on the basis of a single claim of a single patent. Patent life can be leveraged through the judicious use of trade secrets. Industries have sprung up around how to take advantage of life sciences products that are coming off patent. There are some really important contractual considerations that you need to keep in mind in thinking about how to obtain and protect your IP. Before we get started, let me make some introductions. This webinar is being brought to you by Financial Poise, which provides practical and entertaining education for attorneys, accountants, business owners, executives, and investors. You can read more about Financial Poise on slide 55. Our panelists are George Contreras, who is the James T. Jensen Endowed Professor for Transactional Law and Director of the Program on Intellectual Property and Technology Law at the University of Utah. Justin Crotty, who is an IP partner at Saul Ewing. Gillian Fenton, the Executive Director of LST Strategies. And Aaron Foley, counsel and soon-to-be partner at the law firm of Foley Hoag. I am Jay Riley, a corporate partner at Foley Hoag in the licensing and emerging companies practice groups. You can see our names on slide 5, and you can read our bios on slides 49 to 53. Neither Financial Poise nor we intend for this to be an infomercial, so we're not going to take 10 minutes telling you about ourselves. We're going to dive right into the content. If you want more information about any of us, please just refer to our bio slides. Now, about the slides, we have put together a slide deck, but we're not going to be going through this presentation slide by slide. The presentation will loosely follow the slides, and I'll try to call your attention to slides that are relevant to whatever we might happen to be talking about. But this is really going to be more of a discussion amongst the panelists rather than an information dump. So don't worry if you're listening but not watching this seminar. You'll be fine because the slides are not critical. I want to give a shout out and a thank you to our co-producer, the National Law Review. It's thanks to them that we're able to be here today doing this for you. You can read more about the National Law Review on slides 3 and 54. Last thing before we begin, slide 4 contains a disclaimer, and that's really important. You're not our clients. We're not your lawyers. What we're doing here today is for your general education, and you shouldn't act on any of this without getting appropriate advice specific to your situation from your actual attorneys. So without further ado, let's dive in. I want to start with Gillian. Gillian, can you just give us a little bit of a brief overview of just what patents are?
Sure thing, and it's my pleasure to do so. So in the US, there are, broadly speaking, 3 types of patents: design patents, utility patents, and plant patents. In the industry that we're talking about, which is biotechnology and biopharmaceuticals, by far the most important of those 3 is the system of utility patents. Utility patents are designed to protect, for a limited period of time, technological inventions. And they can protect a wide range of different types of technology, from compositions of matter, new molecules perhaps, to formulations, to methods of use and methods of manufacture. So they are widely used across all of the innovative industries, but they are a key part of the business strategy of biotechnology and biopharma companies.
Okay, so Justin, can you review for us the process of getting a patent? What's the lifetime, process of a patent look like?
Absolutely, Jay. So for this part of the talk, we're going to be referring specifically to utility patents, which are for, as Gillian alluded to, inventions. The process for getting a patent is usually referred to as prosecution. That's also the verb. You prosecute the patent from application filing through to issuance. Now, a patent lasts for a term of years. It's a bargain between the inventor and the public, in which the inventor discloses their invention, and in exchange, the public will grant them the exclusive right to use or to allow others to use that invention for a term of 20 years, and we'll get to where that 20 years is measured from in just a moment. So now, even within utility patents, there are quite a few different types of patent applications, and the first one that's usually filed is called a provisional application. So provisional applications are, it's a little to get your head around. So they're never actually examined, and if you do nothing, they just become abandoned with no further action being taken, no rights being granted, no one at the USPTO ever paying any attention beyond what it took to simply issue a filing receipt. Um, but even a provisional application should disclose the invention and describe it in enough detail that someone could make and use it and understand what's being disclosed. Because the reason to file a provisional application is that it plants kind of a flag in the ground and establishes a priority date, which can be part of a priority claim. So, based on what I'm telling you, you probably understand that once you file a patent application, it's not going to be examined immediately, even if it were a non-provisional application. So, it would be a bit unfair for the patent office to accept the application, pick it up years later, and then reject it because it's obvious or anticipated over something that was disclosed in between the time that application was filed and when the examiner picked it up. So, patent applications are examined as with respect to the state of the art as of when they were filed, of their priority date, and a provisional application will establish that priority date. So the purpose of doing so is that during the lifetime of that provisional application, usually towards the end of that 1 year pendency, an applicant will file a non-provisional patent application. And this is, a pretty weighty choice for a lot of companies because they need to decide at this point whether they're going to pursue international rights or whether they're going to focus solely on the US. If they're interested only in the US, they will file, well, this really is just a utility patent application, or as many people would think of it, just a regular patent application. The other way to go is called a PCT, or Patent Cooperation Treaty application. You can kind of think of this as the on-ramp to the highway that gets you patent protection around the world. Because once you've filed a PCT, you have a period of 30 months from the earliest priority date, which may be the filing date of the PCT if there was no provisional application, or it may be the date that provisional application was filed, to make what's called national phase entries. National phase entries could be pursuing a patent application in the US, could be pursuing a patent application in the European region, or it could be pursuing a patent application in any country that's a party to the treaty, which is almost every country. Um, it's not until those national phase entries, or if you file directly in the US, that utility patent application is picked up by a patent examiner, that the application is ever actually scrutinized. And that examiner will be thinking very carefully about a series of legal requirements, some which probably almost everyone would guess exist or are very familiar, and some of which are a bit more arcane, such as, was this out there already? Is it really an invention? Or had somebody else come up with this and disclosed it years before the application was filed? They'll also be considering whether the applicant has described their invention with enough precision and enough detail that it is enabled or someone could recognize they've invented what they've invented. And if any of these requirements are found to be deficient, the USPTO, or whatever patent office around the world is examining it, will reject the application, and the applicant will have a chance to revise the monopoly, which they're asking for, as defined in a part of the patent application called the claims, which is the legal description of the invention. If they're unpalatable to the patent office, they can be amended. Or the applicant can simply argue back that, well, we disagree for these reasons, please reconsider. And sometimes that works. Sometimes you'll have an argument with the patent office that you absolutely have to win. As I alluded to before, there is a patent examiner who will handle this case, and it's it's a little bit like a series of angry letters back and forth between the applicant and the patent examiner to determine when, if ever, the patent application is in condition for allowance. And there's methods of appeal, etc. If if the two sides can't agree.
So, Justin, you sort of alluded to a bargain almost being made between the the inventor and the granting of a patent. The inventor getting exclusivity in exchange for putting their patent out into the public domain. Aaron, can you talk a little bit about what it means for patents to publish? What that actually looks like. Obviously, the disclosure of an invention through the mechanism of a patent um, can expose a company's competitors to some really sensitive information. So how does that work? What should people be thinking about as they're thinking about whether to publish, when to publish? Can you keep the contents of a patent confidential? When does it get revealed? Are there ways of protecting it? And also, Justin kind of alluded to, the examination of prior art. Are there ways to trip over yourself in terms of, what's in the public record?
Yeah, thanks, Jay. These are all really important questions. So of course, the process of publishing a patent means that the patent application is made public by the Patent Office. And so this might be the USPTO, it might be WIPO, which is the Patent Office which handles PCT applications. It could be a foreign patent office. And basically what happens when the patent application is published is that anyone in the world is able to see the contents of the patent application. And like you said, this is fundamental to fulfill the kind of quid pro quo involved with patents. But it can be a very scary time for inventors and companies. It feels like you're basically exposing your secret invention, right? So patent publication typically occurs 18 months after the earliest priority date of a patent application. So if you file a provisional application, the publication will occur 18 months later. If you file a non-provisional, like a PCT application with no priority claim, the publication will still occur about 18 months later. So the good news about that is that there is a period of time, right, between when you file your patent application and when it actually becomes published. And that period of time, that 18-month period, can be really valuable for the company to kind of hone and refine its commercial strategy and think about whether there's anything else that that they want to file on. So the reason that you would want to file additional patent applications before that 18-month date is that as soon as the patent application publishes, it becomes what's known as prior art. And so prior art is basically just something that is out there that is known to people in the field. And it becomes fair game for patent examiners to cite against future patent applications. So if you think about it, right, your patent application publishes. It then becomes prior art to third parties, which is great from a defensive perspective, right? It's now third parties can't patent what you have you already filed on. But it can also cause problems for you as a company because your own patent application might be cited against you, right? And so what I had mentioned a few minutes ago, if if your company is inventing and innovating in a particular field with a particular technology, it can be really important to file any additional patent applications within 18 months of that first filing, which will basically mitigate any prior art effect of your own filings on your own patent applications.
The predictability here is really, I think, a saving grace of this system because companies can plan for this and file their next application before the first one publishes in the situation where they would prefer to keep the first application out as prior art during the examination of their second.
Right. And it also has some implications from the standpoint of how much can a third party who wishes to understand what's out there that's already been patented, how much can they ever actually learn? They're always, if they're looking at patent databases, such as through the US Patent Office or other databases, they're almost always looking at a period of time that's 18 months ago. They're looking back in time when they're looking at those patent applications. That's a good reason why companies should be very cautious when they're asked to give representations and warranties of no infringement, because there's always a gap in your knowledge.
Yeah, absolutely. But just while we're on the subject of prior art, I wanted to mention a few other things, right? So of course, when your patent application publishes, it will become prior art to third parties and also to your own company. But prior art can be really anything that's publicly known. So if your company is putting things on its website, publishing in scientific journals, presenting at conferences, doing posters, abstracts, things like that, that's all considered prior art as well. And so I think, in terms of when you're thinking about patent publication and filing and timing and all of that, it's really important to also consider what else your company is putting out there and making public, and to have a strategy about how that is timed and how it's controlled. I've seen some companies do a great job at this, and some companies, struggle with it. I know in our industry, right, we're taught to publish or perish. And so, as an IP attorney working in-house, for example, you're always going to be kind of battling with your scientists who want to put everything out there. And you have to sometimes basically explain to them why that might not be beneficial from a patent perspective. So yeah, my piece of advice here is just make sure that you have a really strong system and policy for reviewing any publications or anything else that's leaving the company. It should be reviewed by your in-house patent counsel or outside counsel before it gets released. I also wanted to mention at this point kind of an interesting part of patent law, and that is grace periods. So there are particular countries, including the US, but importantly, not including Europe, that have what's called a grace period. So if you publish something and you forget to file a patent application, or for whatever reason, a patent application just doesn't get filed before it's published, you have a period of time, sometimes 6 months, or in the US, it's 12 months, where you can file a patent application, and that prior disclosure will not be considered prior art. So this can be really great if you have a situation where you didn't realize a scientist was speaking at a conference and they accidentally, presented an abstract or whatever. There's still some wiggle room for you, at least in the US and some other countries, to file a patent application and not have to deal with that disclosure as prior art. But that being said, right, it's best if you don't have to rely on the grace period if necessary. So, it's good that it's there, but try not to rely on it if possible.
Yeah, grace periods they can be a real saving grace for simple companies that are only interested in the US, or to make the best of a bad situation. But it can also dictate your filing strategy because, for example, Japan has a grace period, but they measure it against the time of, I believe it's PCT filing, if not actually the filing of the Japanese application. So relying on, for example, a US provisional application to get back through the grace period is fine in the US, but you might have blown your Japanese rights when you otherwise might have had them.
Yeah, there's particular formal requirements you have to make sure are being met as well. So for example, when you file the Japanese application, you have to declare what the prior art is, right? The grace period prior art. And if you don't meet that requirement, then you're really out of luck. So it can be a very tricky process to take advantage of these grace periods.
So I think
Yeah.
oh, go ahead, Gillian.
Sorry, I was just going to say, from the in-house counsel perspective, one of the things I learned that I had to do that was very different from my experience being in private practice, where a client would come forward with an invention disclosure and want to have it turned into a patent application. When you're in-house, it's important to think about the early end as the technology is evolving and developing. IP counsel ideally should be in close communication with your product or technology development team and develop some type of a system for tracking technology as it's in the course of development. That way you can start to develop a view of what would be the most attractive commercial aspects of whatever that new discovery or technology is. And as the team is going forward and maturing it, sometimes everybody's in alignment that it needs to be filed on and protected as soon as possible. And other times, for whatever reason, the team may have other priorities, and you will want to, as in-house counsel, monitor that technology and think, given what I know I want to claim that is valuable, has a disclosure been made that might make a future claim obvious? and what more would need to be put together with that by way of a further disclosure that would really sink my chances of getting a patent protection for this, and then time your actual filing strategy so that you get out there ahead of an enabling disclosure that would really put the desired invention into the public domain.
It's interesting. So with sort of the first third of this discussion that we've had, it's leaping from the screen, the difference in IP protection for life sciences companies from tech companies. It's really, what you've been describing. It's something that the companies really need to be thinking about every day. You need to be intimately involved with the IP protection process from day one. Getting your scientists, your innovators in close contact with your attorneys and thinking about IP strategy on a continual basis, on an ongoing basis, on a real-time basis, and just making sure that you've got not only procedures in place, but also a culture in place that really values that, because it really does go to the heart of what you're going to be able to do with your products 10, 15, 20 plus years down the road. So it starts at the beginning. It starts on day one. That's a key fundamental difference for life sciences companies.
That's right, Jay, and thank you for pointing that out, because on the slide you're showing right now, the patent term is right there. When you file your patent, your utility patent, it's going to expire 20 years from the earliest filing date, subject, of course, to two possible types of term extension or term adjustment. And if you think about the future of your company, when you're in the life sciences field, you know that if you're developing an FDA-regulated product, your path from discovery research to the date on which FDA approves the product that's based on your technology is going to be, 5 years, 8 years, sometimes longer than that. And that can eat into the duration of patent protection that you have when you actually have a product on the market. Completely the opposite situation from many of the high-tech fields where, product development life cycles are much shorter and product commercial lifetimes are also much shorter.
Interesting. I'm going to switch gears now a little bit. George, let me turn to you. Can you talk a little bit about, just what can be patented? And in particular, I'm thinking about, genes and other naturally occurring phenomena and naturally occurring gene sequences. How does that work here in the U.S. and how does that compare with what you might see in other jurisdictions?
Yeah, absolutely. No, it's an important question and one that is, very much still timely today. So the Supreme Court, back in 1980, wrote kind of a very broad and misleading statement, right? In Diamond versus Chakrabarty, the court says anything under the sun made by man is patentable. Not exactly true, right? If you remember the slide that was just up, there were 4 categories under Section 101 of the Patent Act of things that are patentable. That's called patent eligibility, right? What sorts of things are patentable? Processes, machines, articles of manufacture, and compositions of matter. Those are the things that are patentable. That's what we call eligible patent eligible subject matter. So something like a painting, a poem, a novel, the format for a television show, those things are not patentable, right? You can often protect them with copyright or other forms of intellectual property, but not patents, even though they were created by man. So the Patent Act, going back to 1790, had these categories of things that could be patentable. But since the early 19th century, courts have looked at those categories and created some exceptions, right? And the main exceptions that courts created over the years are for abstract ideas, mental processes, and products of nature, right? Those 3 general categories, there's some common sense to it. Like you can't patent the law of gravity. You can't patent something like E equals MC squared. The applications of those laws in particular devices or inventions, yes, those can be patented, but you can't preempt everybody else from using a natural law by patenting it. So this was a general understanding for many years, like more than a century. But then, starting in 2010, the Supreme Court got really interested in patent eligibility again after a gap of many decades. And it heard four cases between 2010 and 2014 that really established what is our modern view of patent eligibility, and one that not everybody is happy with, right? So the case is, In re Bilski, and then Alice versus CLS Bank in 2014. Those two cases relate to financial methodologies, right? These get to the abstract ideas exception. Bilski was about a financial strategy where a utility company could figure out what to charge its customers using a formula so that it could charge, gas, electric, water customers a fixed amount every month instead of charging way more in the summer for electricity and way more in the winter for gas, for example. It's a mathematical formula. Alice versus CLS Bank was about the method of escrowing funds with a third party in a transaction, basically using a computer. Um, those types of claims both were rejected as being abstract ideas. And those are still controversial. We'll come back to what's happening today on that front. More relevant for the life sciences market are the two middle cases, Mayo versus Prometheus in 2012 and Association for Molecular Pathology versus Myriad Genetics in 2013. So Mayo and Prometheus was about medical diagnosis based on the results of tests. There's basically a test kit that you use to measure metabolite levels in a patient's blood after a drug is administered to them. And the claims were written such that the claimed invention was the doctor or the test administrator looking at these test results and then deciding to do something, change the dosage of the medication, basically, based on those test results. And that, the court held, was just a mental process. Not enough was added to make it patentable. Something like the kit itself, the test kit, might have been patentable, but not those claims the way they were written. Mayo versus Prometheus, has been criticized as having a very big effect on the diagnostics market. It remains to be seen whether that's accurate. More interestingly, I think, was the 2013 case that came before the court, AMP versus Myriad Genetics. So Myriad Genetics, a spin out from my university, the University of Utah, was the company that won the race to sequence the BRCA1 and 2 genes, certain variants of which are highly indicative of breast and ovarian cancer. This was a monumental discovery. It was one of the great scientific races of the late 20th century. Really resulted in some important medical breakthroughs in the ability to diagnose people who have these genetic variations as being highly susceptible to these dangerous cancers and able to get prophylactic surgery or treatment to prevent them from developing cancer. So very important discovery. Myriad Genetics had very good and thorough patent attorneys who claimed all sorts of things relating to the discoveries, including the DNA sequences of the BRCA1 and 2 genes, both the DNA sequences of the genes themselves, but also the amino acid sequences of the proteins that were coded by the genes, and many other things, what's called a 15-mer, any sequence of 15 nucleotides in a row that were contained in the gene. So very broad patents. This set of patents was challenged. Why? Well, because Myriad was charging what many people felt to be an excessive price for the genetic diagnostic testing that they were doing. They shut down other labs across the United States that were doing this testing on the strength of their patents, and charged about $3,000 for the diagnostic test, which, at least for the first number of years, was not covered by many insurance policies, wasn't covered by Medicaid. So this led to some significant public controversy. Eventually, the American Civil Liberties Union, the civil rights, civil liberties group, challenged the validity of the patents, their first patent case, and one that surprised many people in the industry and around the world. And to make a very long story short, and to tell you just how long this story is, I wrote a whole book about it. So if you want to read the blow by blow about what happened, it got to the Supreme Court, which ruled that even after you isolate and purify the genes, they are still products of nature. They occur inside of human cells in the same sequence, albeit attached to chromosomes that make them chemically different than they are when they're extracted and cloned in the laboratory, but close enough that a unanimous Supreme Court ruled that nucleotide sequences, amino acid sequences, and the like are products of nature. If they're not altered by humans, they cannot be patented. So this had an immediate and drastic effect on the genetic diagnostics testing market. Prices dropped significantly. It led the next year to one of Dolly the sheep's offspring not being patentable in a case that the Federal Circuit heard involving the Roslin Institute in Scotland that successfully cloned the sheep. And it's led to all sorts of other follow-on effects, including the inability to patent not DNA, but RNA sequences in pathogenic viruses, which back in the days of H5N1, MERS, and SARS, the natively occurring RNA sequences of those viruses were patented. That did not happen with SARS-CoV-2, which was the sequence of which was released in late 2019 and was not patented. So an important case. It has had some important follow-on effects, and we're still sorting out what the impact of these four cases is on patent eligibility doctrine.
So for those of you who are following along on the slide deck, we've sort of been hanging out around slide 19 or so. I'm going to skip ahead to slide 30. Let's talk for a minute about the Patent Eligibility Restoration Act, and then I'm gonna we'll come back. But that's what you've been talking about, George, is so interesting and so important in terms of what can be patented, and the follow-on effects that's had. Can you tell us a little bit about the Patent Eligibility Restoration Act? And I'm curious to hear from everybody what your thoughts are on the act, and what war stories you've seen, what possible therapeutics, what products haven't been able to make it to market, what this might enable, what Pandora's box this might open. Really curious about this whole question of what can be patented.
Yeah, absolutely. Well, so the Myriad case was decided by the court in 2013. There was a subsequent case that Myriad brought on some related technologies in 2014. But by 2015, those cases were unsuccessful, and the industry realized that these naturally occurring sequences would not be patentable anymore, and that the patents that existed, there are thousands of them, were not going to be enforceable. So that led to the initiation of a lobbying campaign to get some of this law overturned. And the first major step there came in 2019 when Senator Thom Tillis, Republican from North Carolina, together with Senator Coons from Delaware, Democrat, introduced the first version of this Patent Eligibility Restoration Act to the Senate IP subcommittee. And what the act and it's been reintroduced like every congressional session since then. There's one currently in committee right now. What it would do is basically abrogate judicial exceptions to Section 101. So all of the Supreme Court jurisprudence going back to Joseph Story in like the 1830s, all the way through Justice Breyer in 2014 would basically be erased from the books. And we would instead have statutory language that would replace those judicial exceptions. So we would still have exceptions for abstract ideas, mental processes, and products of nature, but they would be much narrower than they are under the court's decisions. So, for example, with products of nature, there is an exception in the bill that says, oh, human genes as they exist in the human body or in human cells would remain ineligible for patent protection. But that's kind of like giving the sleeves off your vest, right? Because the genes in the body never were patentable to start with. It was the genes that were isolated and purified in the laboratory, and those would explicitly be patentable once again, as would any natural product. The lichen that you find out in the forest that cures burns. All of those things would become patentable then as compositions of matter, which is the broadest form of protection that you can get for a substance, as long as they're used in a useful product. And so it would significantly broaden the concept of patent eligibility around what used to be a set of fairly robust judicial exceptions.
So I'm curious, let me open it up to everybody. A Pandora's box or, saving legislation?
I would love to jump in. Respectfully, I don't fully align myself with George's characterization of PIRA. It is something that has been designed and developed to correct distortions in the law, which have reflected themselves as distortions in incentives for entrepreneurs to commercialize their inventions in certain fields, and has resulted in U.S. loss of innovation leadership in those fields, such as George properly pointed out, diagnostics. This is something that it's a critical legislative reform that will put the U.S. back onto a competitive international playing field with respect to how other countries and regions such as Europe approach patentability of life science derived inventions.
Pandora's box or necessary legislative reform? Both, I think. So I would start by applauding any effort to address this situation because at the moment I think it's very unfortunate. I think that most people would believe and expect that an invention focused around early detection of a disease that had real health benefits would be something that the US and anywhere would support and encourage. But the Supreme Court's 101 jurisprudence has put us in a place where the patent office is, if the door is not closed, then at least there is a big asterisk over any kind of invention like that, most particularly any invention based around the relationship between genetic expression and health outcomes. And that is an incredibly rich area in US technological development. So I would love to see a better framework, and I think that Congress is constitutionally the right organ of government to address this. Will PARA do it? Maybe. I don't think anyone really knows how this will play out because even if the law is passed, the Supreme Court and the Federal Circuit will have their chance to interpret it. And regardless of where the actual law ends up, it will throw the Patent Office into disarray, which is one area where I think people don't realize it was an impact of 101 jurisprudence, is that it took examiners and the USPTO a long time to figure out what this was going to mean and to go from the opinions that the judges wrote to a system where one could efficiently evaluate and adjudicate the patentability of various patent applications.
Yeah, and I agree. In my practice, I mean, the place that I see the most impact of the 101 jurisprudence has been on biomarker inventions, right? Which Justin mentioned, which is, some kind of genetic variation and outcome on health incomes or impact on health outcomes. So I would love to see some mechanism that would increase, the chances that those would be considered patentable. I also am not sure if this is the right way to do it or if this is written in the way that will do this. And I am a little bit cautious that this is going to cause just more uncertainty, right? I feel like we've been dealing with 101, these 101 cases now for 10 or 15 years, and everyone has kind of a more clear picture of the law now than we did 10 years ago. And this is really going to upend things again, maybe for better, maybe for worse, not clear.
And I'll throw in one final word then, because I certainly appreciate the Gillian's and other skepticism about the 101 jurisprudence as it is, and certainly on the software and algorithm side, I think there's probably more confusion than there is on the life sciences side. But to come back to this pathogen example, so the SARS-CoV-2 virus RNA sequence was not patented when it was first sequenced. Nevertheless, there was a huge amount of space for innovation and patenting, as we have seen with the mRNA vaccines that were developed by companies like Moderna and BioNTech and others, all using that same base, right? So and we have numerous patent litigations going on right now around the mRNA technology space. There's no shortage of patents in the area. And in fact, opening up some of these basic products of nature for everyone to use in their innovation seems in many ways to promote innovation. The other big risk that is just underappreciated in this discussion, where many Congress people point to these cases and say this is hurting American innovation, and we need to get these patents back online because American companies are being hurt. Well, the truth of the matter is that with respect to pathogenic outbreaks, they're not happening in America. They're happening in undeveloped or less developed countries where humans and animals are in close contact on a regular basis. This is China, Indonesia, the Congo, Zaire. These are where the deadly outbreaks happen. And these days, public health officials in all of those countries have the simple technology necessary to sequence RNA, and they will and do sequence it, and they are the ones who are going to get the US patents on these pathogens. And they are the ones then who are going to hold up the US companies who are trying to develop vaccines and therapies based on these sequences. And we've seen this happen. We've seen Indonesia and countries who have isolated pathogen outbreaks try to hold up the pharmaceutical industry and say, well, we'll give you these samples of this virus if you promise that you'll give free vaccines to Indonesia in perpetuity. And that I don't think helps, American innovation.
So let me move on. I would love to keep talking about this for another 45 minutes, but let me move on. Let me come back. There's a very important topic that we haven't talked about yet. We've been pretty focused on patents. And Justin, I'd like to turn to you. I'd like to ask you to just chat for a few minutes about trade secrets, which Patents are all about transparency, and trade secrets are the opposite. And tell us
Sure.
about this very important arrow in the quiver for life sciences companies, that is the trade secret.
Absolutely. Thank you, Jay. So I referred to a patent as a bargain between the public and a private party in which the private party discloses and gets a right to exclude. You certainly don't have to make that bargain. And in fact, if you're a critical calculation is before filing a patent is, well, what's the patent I might get out of this likely going to protect? And if that's unappealing, or you just think no one else is going to figure it out, you can certainly keep a trade secret. A trade secret is commercially valuable non-public information. So it's the formula for Coke. That's a classic trade secret. And trade secrets are protected in the sense that if you break into Coca-Cola headquarters and break open the safe and you run out of the building with a piece of paper that has that formula on it, the damage you've done is not just stealing that piece of paper. The information itself has value and you will be liable for that. On the other hand, trade secrets are not protected from people figuring it out on their own. If you just figure out what the formula for Coke is, then Coke has no cause of action against you. So that selectivity is really key. And once you have determined what trade secrets to keep, and part of the value is that they last until they're no longer valuable or until someone can figure it out without your assistance, you have to protect them. And that's the other half of trade secrets, is that if you're going to keep a trade secret, you have to act like you have a secret. You can't be telling people. If you must disclose it, it must be under a confidentiality agreement or some other contractual obligation that prevents the receiving party from disclosing it. You shouldn't be telling it to anyone who doesn't need to know, including your own employees. And when you do disclose it to even your own employees, you need to make it clear to them that this is a trade secret and it's not to be shared publicly. A whole system of protections in order to protect this valuable non-public information is necessary if you wish to keep the option to consult the courts for redress if someone takes it.
So I guess I'll just reiterate one thing, that if there's one takeaway to remember on the trade secret piece of this, trade secrets aren't just confidential information. They are, but having a confidentiality agreement in place is not enough to designate something as a trade secret. You have a set of statutes that really create some expectations of exactly what companies need to do in order to create trade secrets and maintain trade secrets, and thus to be able to enforce trade secrets. So it's really important to address trade secrets as part of your strategy very affirmatively, very conscientiously, and with some measure of structure. Gillian, you and I have lived together the power, the synergies that trade secrets and patent can play with each other. If you could talk for a little bit about how those two can really complement each other.
Oh, sure thing. Thanks. And you're correct that in many circumstances, technology lends itself, if it's going to be licensed from an originator to another company, say, for example, that is better positioned to scale the technology and commercialize it. Often you get technology bundles that include both patent rights and trade secrets in a single license. So it's quite common that happens, especially in the life sciences. Trade secrets are valuable as a component of an intellectual property strategy because, as Justin pointed out, they can be extremely long-lived, as opposed to patent rights, which have a statutory expiration date that, there really isn't much way around that. And if you've had to burn up a lot of your patent term in the course of development, let's say clinical development of an FDA-regulated product, then your period of patent protection, once the product is approved by the FDA and commercialized is going to be comparatively short, but your trade secret protection can survive and last for much longer. In the life sciences, unlike many other industries, we do have examples of very long-lived, commercially successful products for which trade secret protection of appropriate components of the technology becomes increasingly valuable as the product ages. And I'm thinking as an example here of something like a vaccine that can have a very long commercial lifetime, and it may be a complex product for which the manufacturing technology is a critical part of the value. That manufacturing technology may be perfectly suited to be a trade secret.
Great, thank you. So last question about the topic of patents, Erin, let me ask you, AI is the topic of the day, right? AI has impacted every aspect of our lives. What have you seen in terms of AI and how it's affected, your life as a patent prosecutor and your practice?
Yeah, absolutely. I think when ChatGPT first came around, the patent attorneys were running through the halls saying, "Oh, we're not going to have jobs anymore because AI is just going to write all of our patent applications now." And I think where we're at is that, AI is a helpful tool to help write and prosecute patent applications, but you still definitely need the assistance of a good patent attorney, and the input of a good patent attorney to make sure that things are happening appropriately. There are various tools, as a patent prosecutor that we use every day. There's programs like Harvey. There's a program called Solve Intelligence. And these programs can help, write arguments. They can help write patent claims. They can help write patent applications. And I think their usefulness, at least at this point, varies depending on what technology you're in, right? If you're in a medical device or writing a software type patent, that might be very different than if you're writing a patent directed to a large molecule, small molecule, something like that. So I know that we have kind of experimented of having AI write patent applications, and we're confident that for some technologies we can kind of get a B- out of it. But really it takes a skilled patent attorney to really review that and make sure that the patent application is still appropriate, still meeting all the legal requirements, and still a robust enough document that's going to provide adequate protection. So I think going forward. Oh, sorry, go ahead.
Go ahead. No, I was going to say, so that's the application itself. What about the underlying patent strategy? Is AI helpful at all in playing a role in crafting a patent strategy, or does that still need the intervention of the human?
Yeah, it's interesting. I haven't asked AI yet to craft a patent strategy. I'm curious to know, kind of what it would spit out. But I think, like anything in this field, you really value. It's really valuable to have someone that has seen this kind of play out over time, and knows, the important aspects of patent strategy, and knows, when you should be filing patent applications, what kind of applications you should be filing, where you should be filing them. I don't think we're at the point yet where AI is going to be replacing a human for that kind of advice.
Let me switch over to contracting protections of AI. It's securing AI. We've been talking a lot about the infrastructure that exists to protect AI, but let's talk about the generation of it. Justin, there are a lot of contracts that companies use, service providers use, employers use to secure AI, to secure IP ownership. Can you talk about some of the key provisions that you need to have in your agreements to make sure that you actually own the IP that you think that you're getting?
Absolutely. Thanks, Jane. So the key concept to keep in mind is that just because the contract says that you should own the IP, or even that you do own the IP, does not actually effectuate the transfer. There needs to be specific language of assignment from whomever is likely to own or have generated the IP prior to the contract or prior to that invention, to whom should have it. It's the key distinction is an agreement to assign versus an actual assignment, or I suppose even just a statement that the IP is owned without any mechanism for it being transferred to the people that that should own it. You want to look out for present tense action verbs and a secondary follow-up if necessary to say company shall own the IP. Service provider shall assign the IP to company and hereby does assign the IP to company.
Okay, great, thanks. George, how has AI impacted the way we do business with each other? You know, these contracts that we're entering into between companies and with employers and service providers. How's AI changing that world?
It's definitely having an impact, right? According to the latest ABA surveys, something like 40% or so of law firms are already using AI in contract related tasks. The research that I've done shows that AI tools, even legal fine-tuned tools that many law firms have, they're much better at reviewing and commenting on somebody else's contract or your template contract than they are at generating text from scratch. There really isn't a good AI program yet for generating a whole contract beyond, say, a two-page non-disclosure agreement. Certainly something like a patent license agreement is beyond current capabilities. But reviewing a patent license agreement that you get over the transom from another party against either a term sheet or a playbook that your company has put together with your lawyers, or the things you like and don't like in agreements, that is happening, and it's actually not bad.
Great. Gillian, how do you approach the license agreements that you enter into in the collaborations and the strategic ventures? What's your approach?
Yeah, thank you. Thank you for the question. I, you know, yes, it's good to think about building a license agreement or a collaboration agreement or whatever you need from scratch based on a term sheet and fill it in with terms that reflect both what the parties intend to do and best practices. I have not myself actually found much use yet for AI to help in that drafting process, but I'm sure that it's going to come in the future. The only watchword that I would give to anyone who's involved in negotiating and drafting a new collaboration agreement or a new license agreement or a co-development agreement, what have you, is to think very holistically about what is everything that you need to be true or even not true in order for your company to succeed at that, whatever that venture is. I do see a lot of times that there are agreements out there where the parties must not have fully thought through the scenarios and especially the incentives that each party might be, acquiring based on what's in the agreement. And you can definitely use your agreements to incentivize positive, productive, desired behavior. And just be very careful that you're not accidentally incentivizing something that is counterproductive.
Great. Well, does anybody else have any last patenting tips, patent strategy tips, licensing tips, AI tips, any last thoughts from anybody? I'll throw out a very specific question. What can companies do who don't actually have a patent? How can they protect themselves? How can they go onto the market? What can they do? What's their best bet? What's their best lifeline if they're losing patent protection and they're about to be exposed without any underlying IP? Any thoughts there for tips for life sciences companies?
I'll jump in first. I would say think very holistically about what are all of the things that make your company successful and that give you a competitive edge. You might find that there is an underappreciated trade secret that you have, or you might find that there's something that you hadn't initially considered patenting that actually is patentable and can be developed as a new asset for your company. Just, think broadly and think creatively. This is a great opportunity.
Yeah. And I'd say patent expiration shouldn't come as a surprise to anyone, given that we know when patents are surprising. So companies should be like at least 5 years out, planning their strategy for the patent cliff, for whatever their main product is. And often that strategy involves finding some other small companies that do a patents and buying them, or merging, or somehow getting something into that portfolio. Because once you fall off the cliff, it's tough. There's not that much you can do.
Yeah, it's the difference between life sciences companies and tech companies. The strength of the life sciences company is on that trade secret or on that piece of patent, instead of the brand. Which is the case with so many other types of companies. Well, everybody, thank you so much for a really engaging discussion. I apologize, we've got to end here. There's a lot more that we could cover, but we've reached the end of our time. For those of you listening in, please feel free to log into Financial Poise. You can review the deck. There's a lot of content in the deck that we didn't get a chance to cover. That's some really good and helpful additional comment. So I want to say thank you so much to George Contreras, Gillian Fenton, Aaron Foley, and Justin Crotty. Thanks to all of you for joining us today. And again, thanks so much to our sponsor, the National Law Review, for supporting us and enabling us to be here today. Thanks again, and we'll see you next year with our new session, Life Sciences Level 2.
Thank you. It's been a pleasure.
Thank you.
Bye-bye, everyone.